How you doing, people? Robert here, AKA Robess Anti-Corruption Scotland. I've recently done a Freedom of Information request to the court service relating to the Summary Warrant Application process. I now have an answer, and as follows. It's from the guy, Sean Jammers, that works for the court services. Dear Robert Sproul, thank you for your request for information received by Kilmarnock and Paisley Sheriff Court. They were forwarded to the correspondence team at the Scottish Court and Tribunal Services to provide a collective response. Please see the answers to each part of the request in turn below. Question 1. When a summary warrant application is applied for by sheriff officers, what is the process and how is the alleged debt verified and by who? The answer is it is up to the local authority to submit an application for a summary warrant to the court conformity with the relevant legislation, namely under Schedule 8 of the Local Government Finance Act 1992. They submitted a link. I'm not interested in the link, that's relevant to the person. The application summary warrant paperwork is produced by the applicant and submitted by the applicant to the court for consideration. The Sheriff Court administration staff, do you hear that, people? Administration staff, part of the corporation, lay the application before the sheriff and then advise the applicant of the decision. Question 2. Does the summary warrant process go through a lawful court or a hired room for the day by Glasgow City Council, and who presides at the court? A sheriff or an independent body within the public building? The answer is the sheriff will consider and sign the warrant in their chambers within the relevant sheriff court building. Question 3. Why is no one notified of the process when the process of the summary warrant is applied for by sheriff officers, so he or she can come and challenge the alleged debt through a lawful process which he or her is her right in law? The answer is where the local authority makes an application to the court in conformity with the relevant legislation, the sheriff must grant a summary warrant authorising the recovery of the sums due. The summary warrant process is a means for the public creditors, such as local authorities, to pursue the amounts they are owed on behalf of the public. Very interesting, people. I don't have a contact with the public. The legislation makes no requirements for a court hearing to be set up, and any challenge to a summary warrant being granted should be lodged with the relevant local authority directly. Council tax may be levied and collected in the terms of Section 97 of the Local Government Finance Act 1992. Schedule 8 of the 1992 Act provides for enforcement action in relation to non-payment of council tax. They've sent another link. Again, I'm not interested. Underneath the link, people, it says the Council Tax Administration Enforcement Scotland Regulation 1992 outline further requirements placed on the applicants. Underneath that, there's another link. Again, I'm not interested. Question 4. Why is there never a copy of the alleged summary warrant with wet ink signatures sent to who it concerns? The answer is it is a matter for the local authority which paperwork it supplies to the debtor, meaning they decide what they do fraudulently. Number 5. Where does the charge certificate come from? Is it issued by the court direct or from sheriff officers? The answer is once the summary warrant has been issued, the local authority may serve a charge for payment. A charge for payment will be served by sheriff officers and messenger at arms. For further information regarding charge for payments, contact should be made with the relevant local authority. Fictions, people. You're dealing with fictions and corporations, name man and woman. Number 6. What document is issued to arrest wages and bank accounts? Does this document come from the court or issued by sheriff officers direct themselves, direct from their company? The answer is the sheriff court does not administer earning arrestment or council tax unless it is part of the conjoined arrestment order. Generally, any earnings arrestment would be dealt with a solicitor, debt recovery firm or sheriff officers on behalf of the creditor. The sheriff court only has a role in procedure with application for a conjoined arrestment order is lodged, and the sheriff will then consider the application. Question 7. Is there a contract produced between sheriff officers at the summary warrant application to show a breach of contract in terms and conditions have been broken and the debt is part of those terms and conditions and the contract? The answer is the purpose of the Scottish Courts and Tribunal Service is supporting justice. Ha ha ha. Which we do by providing people, buildings and services needed to support the judiciary, the courts, the tribunals and the Office of Public Guardian. The Scottish Court Service function is to administrate and has no involvement when the functions of the sheriff officers and how they perform their work. There you go, people, there's an important question answered. Sheriff officers enforce court orders on behalf of the applicants, case parties, and not on behalf of the Scottish Court Service. Question 8. Is the alleged summary warrant when issued in the all caps name or any other format? There is no requirement for these documents to be in the all caps name. The format of any document served on a debtor by a sheriff officer is not something which the court services can advise on, right? Question 9. What prima facie evidence is produced to verify the alleged debt? The legislation states that the application by the authority must be accompanied by a certificate for the containing such particulars as may be prescribed. It is up to the local authority to evidence the satisfaction of the sheriff for the summary warrant to be granted, right? And the last question and answer is, can somebody that the summary warrant applies to get a copy of the summary warrant direct from the court that issued it? And if not, why? It says here, once the sheriff has granted the summary warrant authorising recovery of the sums due, the paperwork is thereafter returned to the relevant local authority. Well, there you go, people. That's the thread being hidden for the people. Everything goes back to them. There is no record in the court, and I can verify this right now because I've got somebody emailed the court and they were told there was no summary warrant on record in the court. Right? I'm going to do a part 2 video on this because it's important. Right? The answer was, as I've just said, once the sheriff has granted the summary warrant authorising recovery of the sums due debt, the paperwork is therefore returned to the relevant local authority. It says here, I hope this information has been provided some assistance. However, should you feel dissatisfied with the response or any manner in which the request has been handled, a Freedom of Information request provides for a review process to be conducted. Should you wish to take advantage of that process, you may apply in writing for a review. Your request should provide details of why and you wish a review to be carried out, and you should make the review within a 40-day working period in receipt of this letter. The Freedom of Information Officer. There you go, people. Escaping liability, right? Legalese, word trickery. Now, I'm going to do a part 2 of this video, right? Because I want to go back over this and pinpoint things, right? Because this isn't satisfactory. The question you've got to ask yourself is, why when they go to this alleged court would they give every document back to the sheriff officers, because that's who's there, and for them to return it to their local authority, right? Why would they do that? Because it's all fraud. The Acts, the legislation 1992 Government Act, people, is relevant to the person. Your name's not in the Act, it doesn't say man or woman. That's why they use the word person, as I keep saying. This is where the people are getting caught out, and people have to start listening to myself and Anti-Corruption Scotland because we're giving you the right information for the right reason. Right? Now this is came from the horse's mouth. Can't be denied, can't be rebutted. I've told you. So what to do is watch this video over and over. Write down what you're hearing and decipher the information and get it in your head what's going on. I'm going to do a part 2 video, right? Because I'm not happy with this response, right? You're up against corruption at the highest level, people. You're up against fraud, communicating threats, and theft of property, which is all crimes in Scots law. That's what's happening, and this is what's attempt to happen. So please, people, pay attention to this video. Make it viral. It's important this information gets out, what I've just put up here. It's diabolical what's going on here. And you people sit back letting this happen. Where is the fight? And where is the heart to stand up for your rights and protect yourself for your equity and everything else, right? Enough is enough, people. We don't have to put up with this. We're governed and policed by consent, right? These are all corporations acting in fraud. They don't have the power. Plus, the government and the councils don't have money. It's all an illusion. Anyway, please share this video far and wide and take care. Be safe, people. And I will speak soon to you again. Thank you for taking time to watch the video. Thank you for all the new subscribers to my TikTok. It's appreciated. Keep them coming, people. The information is coming your way. In the next video, I'll address this again. Right, people? Thank you. Take care. Be safe and have a good day.